Honorable Justice G.R. Swaminathan, Honorable Dr. Veerappa Moili, Professor Dr. G.B. Reddy, Professor Madhubushi Sridhar, Professor Sarfraz Ahmad Khan, all the faculty members, students, invitees. It is on a very important topic of a great contextual importance that this panel discussion is taking place. The topic is the evolution of public morality and constitutional morality, an analysis of recent Supreme Court judgments. In this panel, I have a company of very esteemed scholars who have very in-depth knowledge of the subject and very good insight about various issues relating to constitutional and public morality. They will be discussing on various specific issues. Before calling upon each of the members, requesting each of them, let me point out that constitutional morality is primarily a value framework which the polity as a whole has identified for the purpose of its governance. It is the essential virtue which a constitutional polity should inculcate. It is a set of principles, norms, which form the very conscience of the Constitution. It embraces within its sphere several virtues, foremost of them being the espousal of a pluralistic and inclusive society. The essence of constitutional morality is something arising out of the concept of rule of law or adherence to the principles of constitutionalism and abide by various values which it propounds. Aristotle considered that constitutional morality is a must for any organized political community, because it is through constitution that the salvation of a whole of that political community will be possible. To abide by the constitution is a mandatory duty on the part of the public. Morality is basically a principle stating an ideal conduct. And when a society considers or accepts certain ideas as something to be followed, or some ideals or some most appropriate conduct that is to be followed by all, then there arises morality. People set individual ethics for their own good conduct, but when so many such ethical principles are to be balanced, integrated, and there ought to be proper resolution of various conflicts amidst different types of ethical norms, then there arises public morality or social morality. Insofar as a political community is concerned, it is a need of the hour that a political community should abide by the moral obligation to follow the supreme law of the land. So that primary obligation of the political system to abide by the constitutional principles is the base of constitutional morality. Professor Groth, an eminent Greek historian, explains about constitutional morality that it is the mandatory requirement of any democratic system that through such a faithful adherence to the constitutional principles, the people as a whole will be adhering to the basic principles laid down in the Constitution itself. Dr. Ambedkar, citing Grote, points out in the Constituent Assembly that constitutional morality is something to be deliberately cultivated. It is not a natural sentiment. In the backdrop of various types of inequalities, discriminations, exploitations, and the past discriminatory practices or cultural faults, it is essential that there ought to be evolution of such a loyalty from the side of people to the constitutional values in a deliberate manner. So through education, through reform, through people's involvement, there ought to be creation of that type of situation. Then we come across constitutional morality as a norm that was referred in the K.S.L.U case, that when Parliament amends any of the provisions of the Constitution, its basic purpose should be to promote the essential features of the Constitution. Pointing out that judges like Justice H.R. Khanna and others refer to constitutional morality. Then we come across constitutional morality being referred in anti-corruption cases or cases relating to the democratic practices or electoral practices or various types of deviations relating to setting right. Such deviations, principles of constitutional morality are referred. Then during this particular decade, there is a growth of constitutional morality in such a way that it is a constitutional morality that shall prevail over public morality. Of course, the whole of that idea started with the famous Naz Foundation case, where Delhi High Court has initiated the idea that the public morality or social morality should be in conformity with the constitutional morality. And the constitutional morality stands for justice, liberty, equality, dignity. And dignity is one of the essential features there, and it is appropriate that there ought to be such kind of opportunity for the people to have such choices relating to their sexual orientation, and hence Section 377 of Indian Penal Code is to be read down. But that idea of constitutional morality was not accepted by 2 judges bench. Then subsequently in a 5 judges judgment, Nautaj versus Union of India, we come across a judgment where the concerned section was read down, and it was considered that the constitutional morality shall prevail over public morality, and that theme was repeated, or it was reiterated in a number of cases. We find that it was applied to nullify Section 497 of Indian Penal Code, which had withstood the constitutional test for a long time, but in 2018 there was a famous judgment, Joseph Shine case, where the court considered that Section 497 is unconstitutional. Again, it is a constitutional morality that prevailed over public morality. Then we come across the controversial case. There's a Indian Young Lawyers Association case. There's a Shabarimala judgment where the court considered that the term morality under Article 25 of the Constitution reflects constitutional morality rather than a public morality, and prevalence of constitutional morality or social morality or the community practices should be considered as something imperative. It is a proposition flowing from Article 25 of the Constitution. There was this kind of development. Of course, that has given rise to a big debate whether it becomes enforceable when the concerned judgment is opposed by the people, or when a pluralistic society demands for certain types of religious practices which were followed for a long time to continue. It was the view of a minority judge, the dissenting judge, Justice Inder Malhotra, to the effect that in a pluralistic society, tolerance and acceptance of different types of religious practices should be regarded as constitutional morality. So, constitutional morality itself can have two different types of views. The majority view saying that yes, on the basis of liberty and equality, it ought to be regarded as something impermissible, and denial of the opportunity to have entry into the Shabarimala temple on the part of a particular section of a women group is something unconstitutional, because it goes against the dignity of a woman. Because we are living in the era of women empowerment. Article 15 clause 3 is there, and there are so many other important provisions which empower the women folk. There ought to be that kind of approach. But the minority view is that constitutional morality stands for a pluralistic society, and coexistence of different viewpoints or different types of practices should be regarded as appropriate. And women as a class is not subjected to any kind of a discrimination. It is only a specific group, and there are some justifying reasons, and it is based on a cultural practice, etc. Thus, about identification of constitutional morality or conflicts between different shades or different aspects of constitutional morality, there could be debate, and it cannot be regarded as something settled. That's why there is a need for a fine-tuning whole of our discourse relating to constitutional morality. Of course, the panelists will be focusing on various issues. I will be finally making my own presentation about the team. Of course, my view is that in resolving constitutional, in resolving the conflicting constitutional moralities, it is the idea of fraternity that ought to be taken into consideration, that should play a very dominant role, etc. Of course, today we have very eminent panelists. Already there has been an introduction of each of the panelists. First, Justice G.R. Swaminathan, Honorable Judge of High Court of Madras, Madurai bench. He will be speaking about the issue, how it is appropriate to pit one aspect against another aspect within constitutional morality. And the learned judge maybe, yes, he will be making presentation. He will take about 10 to, yes, 15 minutes, 15 to 20 minutes. We have almost 1.5 hours, 1.5 hours. So since we have 4 panelists, of course, 20 minutes for each of the panelists may be appropriate. And I request Honorable Justice G.R. Swaminathan to make his presentation on the concerned theme. On various other themes, other panelists will be speaking, and soon after completion of the presentation by Honorable Justice, I will be explaining about the themes that are going to be presented by other panelists. I request that all these presentations by very eminent scholars should be listened with rapt attention. It should be grasped. It is a very wonderful opportunity for you to develop your listening skill, reasoning skill, and ability to interact